So, my dear friends, today we are going to discuss about the valid requisites or the requirements of valid acceptance. And if we talk about the earlier topic, so there we have covered about the offer and we have covered about the what are the situations or circumstances where the offer gets terminated. So, I hope that particular concept is clear to all of you up till now. And let's start with the rules of valid acceptance. So, my dear friends, whenever we talk about the acceptance, so we have discussed the meaning of offer, and there we have mentioned one thing, that is that to obtain assent of that other. To obtain, we say when a person shows his willingness to do or not to do something with a view to obtain assent of that other, it is said offer is being made. And we say with respect to the acceptance, when the offer is being made and the person gives his assent thereto, then it is the offer is said to be accepted. And when the offer is accepted, then there becomes the contract. Again, I repeat, keeping other things constant, considering that all the other requirements are present in the particular promise. So now when we talk about this acceptance is required to be the valid acceptance. So this particular acceptance, when we are using the word that this he gives his assent thereto, it is said to be accepted. तो इस particular assent की जो requirement है ना बेटा, ये assent उस point of view से होना चाहिए that it should carry all the essentials of valid acceptance as per your Indian Contract Act 1872. तो अगर ये आपकी कोई भी इसकी वैलिड एक्सेप्टेंस की प्री रिक्विजिट या उसकी रिक्वायरमेंट फुलफिल नहीं होगी, so this acceptance will become invalid, and once this acceptance is invalid, it will result into no contract. And if there is no contract, there is no legal obligation. And if there is no legal obligation, then in this particular situation, no remedies in case of Indian Contract Act. Is it clear? This particular chart is clear to all of you that when we talk about offer to be accepted, so offer is being made with an intent to obtain assent of the other party to whom the offer is being made, and if he gives his assent thereto, तो ये दोनों अमाउंट पॉइंट्स की assent yes भी देनी है एंड देयर टू मतलब कि उस ऑफर को एज इट इज एक्सेप्ट करना है, तो उस सिचुएशन में द ऑफर इज सेट टू बी एक्सेप्टेड. Along with that, the prerequisites or the requirements of valid acceptance as per Indian Contract Act should be fulfilled. और अगर वो requisites fulfill नहीं होती हैं तो acceptance invalid हो जाती है, और अगर invalid हो जाती है so there is offer but there is no acceptance. Acceptance वो तब मानी जाएगी जब वो valid acceptance होगी, तो इट विल नॉट रिजल्ट इनटू द कॉन्ट्रैक्ट. और अगर वो कॉन्ट्रैक्ट के फॉर्म में सिचुएशन एग्जिस्ट नहीं करती है तो उस सिचुएशन के अंदर लीगल ऑब्लिगेशन नहीं है, एंड देयर आर नो रेमेडीज ऑफ इंडियन कॉन्ट्रैक्ट एक्ट अवेलेबल विद इन दैट. सो नाउ लेट्स सी द डेफिनेशन ऑफ एक्सेप्टेंस and the further. Now it says section 2(6) says that a proposal when accepted becomes a promise. And when we talk about the proposal, so we have already discussed the definition of offer as per Indian Contract Act, and that says that when a person shows his willingness to do or not to do something, to obtain assent of that other, it is said a proposal is being made. And when that proposal is being accepted, it becomes a promise. So acceptance can be defined as when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. And here we have already discussed about the specific offer and about the general offer. So this will become another essential element कि स्पेसिफिक ऑफर में वही एक्सेप्ट कर सकता है जो जिसको ऑफर दी गई है, और जनरल ऑफर में देयर आर रिक्वायरमेंट्स टू एक्सेप्ट द ऑफर by doing the things required for the acceptance. And in this case, we have discussed about Carlyle versus Carbolic Smoke Ball Company case in detail. So in that situation, the journal offer will be accepted. And similarly, we have discussed about the invitation to offer. तो इनविटेशन टू ऑफर को अगर हम एक्सेप्ट करते हैं तो वो एक्सेप्टेंस नहीं है इनविटेशन टू ऑफर के अंदर. इफ वी एक्सेप्ट दैट इनविटेशन, it will result in offer, and in return this offer is to be accepted. So we have to understand these linkages, these requirements, right? So now let's move further. Now the very first requirement or legal requirement for valid acceptance is that acceptance must be given only by person to whom the offer is being made. So here we can clearly discuss about the specific offer. So when we say the specific offer, so if A is giving an offer to B, so B has the right to accept the particular offer. So C, X, Y, Z, anyone else out other than this will not be in a position to accept the offer. ना वो accept कर सकते हैं, ना वो contract का part बनेंगे, ना वो हमारी performance के लिए जो भी promise किया गया है वो A को compel कर सकते हैं. So this particular concept is called as doctrine of privity of contract. Doctrine of privity of contract. What does it mean? It means that the contract is, this privity has come from the word private. So the contract has come, it's a private relationship between the two parties who have entered into the contract. So to whom the offer is being made, if that person accepts the offer, then it will result into the contract. If someone else accepts the offer, it will not give result into the contract. So कॉन्ट्रैक्ट किसी के भी फायदे के लिए हो सकता है, लेकिन कॉन्ट्रैक्ट उन्हीं दो पार्टीज के बीच में होगा जो ऑफर करेगी और जो उसको एक्सेप्ट करेगी. सो इन दैट केस ए, क्योंकि हम कहते हैं कॉरेस्पॉन्डिंग राइट्स एंड ऑब्लिगेशन है, तो ए कैन कंपेल बी टू परफॉर्म हिज पार्ट ऑफ ड्यूटी एंड बी कैन कंपेल ए to perform his part of duty. So this rule, doctrine of privity of contract, says that only parties to contract can sue each other. तो इस केस में हमें ये ध्यान रखना है कि जो एक्सेप्टेंस है वो वैलिड है. एंड ऑफर प्लस एक्सेप्टेंस वी हैव ऑलरेडी डिस्कस कि जब वो ऑफर एक्सेप्ट हो जाती है तो वो एक कॉन्ट्रैक्ट के फॉर्म में आ जाती है, उसमें लीगल ऑब्लिगेशन आ जाती है, तो पार्टीज कैन नॉट टेक देयर स्टेप्स बैक. सो इन दिस पर्टिकुलर केस, this case, Bolton versus Jones case, says that A sold his business to his manager B without informing his customers. And C, a customer had a running account with A and sent an order to supply to the goods to A by name. B executed the order. A refused to make payment. C was not liable. क्योंकि जब C ने वो ऑर्डर प्लेस किया तो उसने ऑफर किसको दी? A को. बट वो ऑफर किसने एक्सेप्ट करी? उसके मैनेजर बी ने. सो इट मींस कॉन्ट्रैक्ट होना चाहिए था सी और ए के बीच में, और कॉन्ट्रैक्ट जो हुआ, एक्सेप्टेंस हुई, वो हुआ आपका सी और बी के बीच में. So it means it has not resulted into the contract and there is no legal obligation of C to make payment to B. So in this case, this particular rule says that acceptance must be given only by person to whom the offer is being made. So I hope up till now the first point is clear to all of you.
Yes, ma'am.
Okay. Now let's move further. Then second very important essential comes, acceptance must be absolute and unqualified. So जब हम बात करते हैं word there to की, so this there to says कि जब हमने ऑफर करी, so it should be accepted 100%. ऐसा नहीं होना चाहिए कि I will accept this thing, ये तो मैं कर लूंगा, but ये चीज और ये part of offer I am not going to do this. So in that case, the acceptance will become invalid. Secondly, this should be unqualified. It means there should not be any kind of conditions. There should not be any kind of negotiation. There should not be any kind of cross offer, or there should not be कि आप उसको accept नहीं कर रहे हो. So once the offer is to be accepted and their valid acceptance is required and it is going to give rise to a contract, so acceptance must be absolute and unqualified. So we say that it should be accepted 100%. You cannot accept part of the contract. That, for example, I am ready to sell 1000 rupees, 1000 units of something. So you say I have a requirement of 800 units and you can send me 800, but remaining 200 I am not going to buy. So in that case, the ball will come in the court of the offerer again, that if he renews the offer and agrees for 800, तो वो ऑफर प्लस ऑफर हो जाएगी. आपने 1000 यूनिट्स की ऑफर करी, द अदर पर्सन हैव गिवन द ऑफर टू बाय 800 यूनिट्स. सो इट विल बी कॉन्ट्रैक्ट तब होगा जब फर्स्ट पार्टी 800 यूनिट्स के लिए एक्सेप्ट करेगी, तो उसमें पार्टीज की पोजीशन चेंज हो जाती है. तो एब्सोल्यूट मींस दैट यू हैव टू एक्सेप्ट it as it is, whole of the offer. You cannot make any changes. And when we talk about the unqualified, unqualified means कि किसी तरह की ओरिजिनल ऑफर से डिविएशन नहीं होनी चाहिए, किसी तरह का कोई नेगोशिएशन नहीं होना चाहिए. इवन द स्लाइटेस्ट डिविएशन with respect to the mode of acceptance is going to make the acceptance invalid. For example, you have taken the admission and you have not given the acceptance in the mode by filling up the form, but you have written a mail to the authorities. So in that case, this acceptance is invalid, right? So you have to accept the offer, whatever terms and conditions etc are given in the offer. तो जब हमने ऑफर में डिस्कस किया था, तो हमने डिस्कस किया था कि ऑफर में कैन बी subject to n number of terms and conditions, but they should not contain any term the non-compliance of which would amount to acceptance. So it means that the essential says that offer should be accepted 100%, it should be unqualified, it should be unconditional, क्योंकि ऑफरर के पास राइट है कि वो कुछ भी टर्म्स एंड कंडीशंस उसमें अटैच करके दे सकता है. इफ यू वांट एनीथिंग चेंजेस, that would be a different thing. Another example we can take here is that you went to a particular showroom, car dealer, to buy a particular car, and you have selected a model, you have selected the color of the car, but that particular model carries only the basic things, right? Certain say accessories are not there or certain features are not there, but you want the additional features also. So then you can go for the next model or the fixed items. The terms and conditions say मॉडल ए, मॉडल बी, मॉडल सी, मॉडल डी, बहुत सारे मॉडल्स है. तो आप अपनी रिक्वायरमेंट्स के हिसाब से मॉडल सिलेक्ट कर सकते हो, बट दे आर नॉट गोइंग टू मेक एनी changes as per your requirement. The person cannot say that okay, you select the C model and you just pay me something extra, so I will add the features of D model as well. That is not there. So in that situation, what happens that the offerer have the right to have its own terms and condition, and acceptor is going to accept it as it is. He cannot make any changes in the offer, and if it makes changes in the offer, it will lead to termination of offer. Is this point clear to all of you? You can write in the chat box. Yes, please. Is this point clear to all of you? Right, good going. Okay, now let's move to next point. It says that acceptance must be in the mode prescribed or some usual or reasonable mode. So it means that in this particular case, 3 points are important. One, if the mode is prescribed, it should be as per the mode. For example, if writing is necessary, certain submission is necessary, or a certain form is necessary, certain application is necessary. तो अगर mode prescribed है, so it should be strictly according to the mode prescribed. And if you are not going to follow, it would not amount to valid acceptance. Second thing is that if the mode is not prescribed, then it should be a reasonable mode. Reasonable mode means that you should, the normal mode for the acceptance or creation of this kind of contract which is used, you should use that reasonable mode. So that can be, say, if a person has given you offer by mail, so you can in return make a phone call. If the person has given the send to you the letter, you can send the telegram. So whatever is the reasonable mode for communication, that is required to be used. But that reasonable mode has certain requisites, that if you have sent your acceptance by mail, so it should be properly addressed and properly stamped. If you're sending by post, right? If you're using the electronic mail, then the particular address should be same. It should not be, means आपने तो मेल भेज दी बट आपने गलत मेल आईडी पे भेज दी, तो क्या वो वैलिड एक्सेप्टेंस कहलाएगी? Yes, no?
No,
No,
ma'am.
ma'am.
And if you have sent by post, but you have not written the correct address, so will it amount to acceptance? कि हमने तो अपनी तरफ से acceptance भेज दी, now you are bound by the contract, will it result into a contract?
No, ma'am.
Right.
टर्मिनेशन हो जाएगा.
Right. And there is again a certain requirement that there comes the contract over telephone. Okay. Nowadays, again, we are facing certain network issues or certain problem. But in prior to some time before this, so there were no network problems and all, and you used to have the clear chit chat. Other than this, earlier days when we used to have the landlines and mobile networks were not very strong, so that time there used to be a situation that जब आप बात कर रहे होते थे तो कई बारी the other person have not heard the voice. ठीक है? तो कॉन्ट्रैक्ट ओवर टेलीफोन के अंदर क्या रिक्वायरमेंट होती है कि जब आप एक्सेप्टेंस देते हो, ऑफर देते हो और एक्सेप्टेंस करते हो उसका, देयर शुड बी कंफर्मेशन ऑफ द सेम, that the other person says yes, that I have heard that you have accepted the offer, or I have heard that you have said yes to my offer. So there should be some kind of confirmation in case of contract over telephone, because there can be certain that when you said yes, there was some network issue and the other person has not heard your yes about or the acceptance of the offer. So there can be a situation where the mode is prescribed, we have to use that. The reasonable mode, if mode is not prescribed, and the when we use reasonable mode, conditions are that if you are sending it by mail, properly stamped and addressed होना चाहिए, email से भेज रहे हो तो properly addressed mail होना चाहिए, and there should be, generally we have the habit of writing the mail, that we write the mail from our side and we remain quiet. It's a better best practice that you seek for the acknowledgement of the receipt of the mail. Whenever you are sending any complaint, whenever you are sending some document, whenever you are sharing any application, so one thing is that you keep yourself in CC. Nowadays this is good, that if the mail is bounced and we have received the receipt that the to this particular mail address it could not be delivered, or there is some problem. And second thing is that you can keep yourselves in CC, so that you have the record that you have sent the mail. Secondly, there can be a situation that you have written the mail address, वो मेल तो चली गई, बाउंस नहीं हुई, बट वो किसी और को चली गई जिसने आपको ऑफर ही नहीं करी, तो उस केस में क्या होगा? उस केस में द अदर पर्सन विल नॉट बॉदर, आ गई मेरे मेल अकाउंट में गलत मेल आ गई, दैट्स ओके. बट फॉर इफ यू सीक फॉर एक्नॉलेजमेंट, that please do acknowledge me and the receipt of this particular mail, and let's discuss the further course of action, so it will confirm that you have sent the mail to the right person. And if you have you just add the word, they kindly acknowledge the receipt of this mail, then the other person would be in position that if he has received the wrong mail, so definitely he will reply you back that you have sent the mail to the wrong person or wrong mail address. So these are the best practices. It's not about the subject and the course we are learning here. We are learning the things which we can, adopt in the daily practice as well. Now another thing is the 3 points. देखो मैंने आपको एक लाइन के अंदर कि acceptance should be made in mode prescribed or in some usual or reasonable mode. इसमें हमने अभी 3 पॉइंट्स डिस्कस कर लिए, प्रिस्क्राइब मोड का, रीजनेबल मोड का और कॉन्ट्रैक्ट ओवर टेलीफोन्स का. नाउ द फोर्थ पॉइंट इज द साइलेंस इज नॉट अ मोड ऑफ एक्सेप्टेंस or mental acceptance is ineffectual. Now in this particular situation what we have to understand is that when we talk about the acceptance, so acceptance needs to be communicated. ये आपका अलग another essential आ जाएगा, acceptance must be communicated, राइट? तो इसी का पॉइंट आ जाता है कि अगर आपने एक्सेप्ट तो कर लिया but you have accepted and it is not being communicated. This is called as a mental acceptance. Or you remain silent to acceptance. In this case, the contract will not be considered. There are certain exceptions to the rule we'll discuss, but mental acceptance और साइलेंस में भी आगे दो पॉइंट्स आ जाते हैं. तो मेंटल एक्सेप्टेंस के अंदर एक आपका आ जाता है, वो आपका इसमें ये पॉइंट्स इंटर रिलेटेड है कम्युनिकेटेड का. ब्रॉकटन वर्सेस मेट्रो रेलवे कंपनी केस है एक, वो भी हम डिस्कस करेंगे और साइलेंस में भी डिस्कस करेंगे. सो व्हाट हैपेंस इज that if you have thought, A said, you buy my car for rupees 1,50,000 and the market value of the particular car is 3 lakh, so we have got the good deal, and immediately we got a smile on our face and we said, okay, yes, I am going to buy. But we forgot or we have not communicated. We have in our mind, we have accepted. And बाद में you say, मैंने एक्नॉलेज किया तो था, मैंने उस टाइम स्माइल कर तो दिया था. This will not amount to acceptance. When you have to accept, you have to communicate your acceptance. Yes, I am ready to buy your car. So in that case, this mental acceptance is not a valid acceptance and it will not result into the contract, and you cannot compel the other party to go by this particular mental acceptance. And when we say silent, so in case of silence, the person, if he remains silent with respect to the acceptance, in that case silence would not amount to acceptance. लेकिन कुछ कुछ situations होती हैं where we have the duty to speak. There is also silence is can amount to misleading. So these things we are going to discuss in the later classes wherever these particular points are important. But here, with respect to acceptance, we just have to understand कि silence आपका मोड ऑफ एक्सेप्टेंस नहीं है, वो वैलिड एक्सेप्टेंस को रिजल्ट नहीं करेगा. सेकेंडली, मेंटल एक्सेप्टेंस जो होती है वो आपकी इनइफेक्टिव होती है. इवन दो यू हैव सेड यस इन योर माइंड, बट this remains ineffective. This will not give rise to a contract. I hope this point is clear to all of you.
Yes,
Yes?
Yes,
ma'am.
ma'am.
Okay. Then there comes uncommunicative acceptance is not valid. It means acceptance needs to be communicated. So this Broadgun versus Metropolitan Railway Company case में क्या हुआ था, that there are the facts of the case that they have invited the tenders with respect to the supply of coal, and the board and the manager, they have selected one particular vendor, and they have even write an agreement and sign that particular agreement in the favor of the particular company to whom they wanted to give the particular tender. But the manager forgot to post the letter of acceptance, and this particular letter remained in his drawer. So in that case, because even though they have given the acceptance, the vendor is selected, an agreement is being made, or the particular agreement has been duly signed, but it has not been posted, it has not been communicated, it will not result into the valid acceptance. I don't know, this is okay, no problem. So in this particular case, this is not communicated. तो अगर वो communicate नहीं हुई है तो वो valid acceptance नहीं है, और अगर वो valid acceptance नहीं है तो it will not result into the contract, right? So acceptance needs to be communicated. तो acceptance के अंदर ही फोर पॉइंट्स हो गए आपके: प्रिस्क्राइब्ड इन राइटिंग, रीजनेबल मोड, then contract over telephone, then uncommunicative acceptance, and silence does not amount to acceptance, right? So this particular point can come as a separate 5 marker question as well, that please explain that whether the mode prescribed is valid requirement for the acceptance or not, or there can be a statement acceptance must be in the mode prescribed or some reasonable mode explained. So you have to use the case study, your example, and then you have to explain this particular amount. Then there comes acceptance must be communicated by the acceptor. Now suppose in this case the people, he has, the agreement is being signed, it has been kept into the drawer, and somehow, uh, while cleaning the drawer or taking care of the things, a peon checks and see that this particular letter is or agreement is in favor of this particular company. And this peon was known to that particular person and gives a call to that particular person that yes, your tender is passed and you can, start working on it. So in this case, this call will not be a valid acceptance because it is not being given by the authorized person or the person who has made the offer. So, in this case, acceptance must be communicated by the acceptor. And there is another case law of Powell versus Lee. So, there was the facts of the case that there have been the interview for the particular post in a school, and the persons different persons have been interviewed, and one person got selected, and the managing committee passed the resolution in favor of a person, but that resolution got cancelled later on. A member from the managing committee unofficially communicated that person about his selection, but no information has been sent from the school about his selection. The authorities have not sent any letter, and in this case, the person who got selected filed a case in the court of law related to his selection, but it was held that there is no contract because there has not been the valid acceptance, right? So in that case, acceptance must be communicated by the acceptor. Then acceptance must be given within a reasonable time and before the offer lapses. So this point we are going to discuss when we'll discuss about the time of communication and revocation of offer and acceptance. But here we just need to remember कि जब भी offer हो तो या तो वो given time period हो. Suppose your admission list is open for 3 days until 1 o'clock you can apply, or till 12 or in online mode on a particular day till 12 a.m. you can apply for the particular course, and once the portal gets off after that time you cannot apply. So if it is there, so it is to be given in a given time frame if it is there, and if given time frame is not there, then within a reasonable time period, and reasonable time would differ from one case and one situation to another. So if today someone has given the offer and after 1 month you are saying, okay, I am ready to buy that thing you talked to me in the last meeting, that is not valid. So here we have to understand that the acceptance must be given within a reasonable time period or before the offer lapses, and this we'll going to discuss in detail in the later next class. Then acceptance must succeed the offer. So it means that first the offer is being raised, then there should be acceptance. It cannot go vice versa, that first you give the acceptance and then the offer is being raised. And rejected offer can be accepted only if it is renewed. So even if there is, I have given you the example that I can sell you 1000 units and you says no, I am going to buy only 800 units. So if they, once you have rejected the offer, then also if it is renewed, the person have the right. And if you have made a cross offer, then also original offer comes to an end. If you have made any negotiation or any changes in the offer, then also the original offer comes to an end. So in all these situations, the offerer, if he renews the offer, then only this can be accepted, otherwise not, right? And the next topic of communication of offer and acceptance and revocation we are going to discuss in the next class. And now the house is open for your queries or questions if you have any, right? Any queries or any difficulties, any case study, you can ask.